Welcome, ladies and gentlemen, to this UKLFI Charitable Trust webinar on judicial review in Israel and the UK. In Israel, the current coalition government's proposals for judicial reform have been met with opprobrium from the opposition, and around the world, jurists and political commentators have weighed in. However, the wider debate has so far focused on allegations of the end of democracy and the political divides in the Knesset. It has, for the most part, failed to engage with the mechanics of the proposals and the context that has prompted them. The judicial revolution, led by former Chief Justice Aaron Barak in the 1990s, saw the Supreme Court in Jerusalem take for itself unparalleled powers of judicial review. And these powers are unconstrained by considerations of standing and justiciability, as so many comparable higher courts around the world are. We must at the outset recognise that Israel's system of governance is unique, and comparisons with other jurisdictions will only take us so far. But as UK lawyers for Israel, we could not resist a proper analysis of judicial review in Israel and the UK, the English legal tradition having undoubtedly had a profound impact on Israel's system of law and governance. And to provide that comparison, it's my pleasure to introduce our two panelists. Stephen Hockman, King's Counsel, is a former chairman of the Bar of England and Wales. His career spans over 5 decades at Six Pump Court, where he is head of chambers and a leading practitioner in public and regulatory law, with substantial experience of judicial review. Professor Eugene Kontorovich was Professor of International Law at George Mason. He specialises in constitutional and international law and is the head of the International Law Department at the Kohelet Policy Forum in Jerusalem. We will have brief initial remarks from our two speakers before turning to your questions, ladies and gentlemen, which we will take from the Q&A facility on Zoom. Professor Kontorovich, thank you for being with us. Please, could you begin with an overview of the reforms and what has prompted them?
Certainly. Thank you so much for having me. It's a pleasure to be here. So to understand the changes, one needs to understand the status quo that they seek to change and where it came from. So first, Israel does not have a written constitution, not necessarily for the same reason as the UK, that it has a long history of parliamentary democracy from before the age of written constitutions, and has constitutional statutes of a kind that have formed customary practice and customary usages and arrangements accepted by the usage of centuries. Rather, Israel simply did not have a chance. There was an idea to have a constitution in 1948, but because of the War of Independence, that did not come about. And Israel essentially inherited the Westminster model of parliamentary sovereignty. And that was the situation in Israel for the first 45 years of Israel's history into the 1990s. Now, the Knesset did pass, and it's important to explain these carefully, a series of laws known as basic laws. The basic laws were so-called because they dealt with basic things, like there shall be a legislature, it shall have 120 people and be called the Knesset. There should be a judiciary. There should be the army, chief of staff. These laws were not constitutional in any sense, and in particular, they were thought to be something that could potentially be turned into a constitution later. But the basic laws are passed by a mere majority of the quorum. In other words, they don't require any particular deliberative or supermajority method. All of this was the situation for the first 45 years of Israeli history, for the great majority of which all power lay in the hands of one party or one coalition of left-wing socialist parties headed by David Ben-Gurion. As I was not around for much of this, but I do not recall. This being Israel not being a democracy at the time, or this being widespread contention in Europe that system prevented Israel from being a democracy. A few things happened in the 1990s. Knesset passed a basic law dealing with certain rights, individual rights, which previously were not reflected in any basic laws. And the Supreme Court asserted that that basic law gave it the power to strike down other laws as inconsistent with basic law, human dignity. In other words, the court asserted for itself in the mid-1990s the power of judicial review, which had not been, was not explicitly conferred by statute. That's the first and perhaps most defensible defensible part. So I'm going to turn off the chat because it's a little distracting. So the Supreme Court said it had the power of judicial review. Over the next several decades, it said a few other things. So the power of judicial review, it claimed, is implied by basic law, human dignity, and maybe some other basic laws. So they claim that basic laws have this quasi-constitutional status. And to critics of the court, the judges said, look, we do this with the implied consent, the assent of Knesset. If Knesset thinks we've gotten it wrong and these basic laws do not provide for judicial review or we've misunderstood their meaning, they can always amend the basic laws. Because again, basic laws are passed by a simple majority of Knesset. You don't need 61 votes, you just need the majority of whoever is there, so they can always change it. So since the 1990s, the Supreme Court has said a few additional things which vastly extend its powers. First of all, it has said that it has eliminated any bars of justiciability, standing, mootness, or ripeness. In other words, it has said that it can review cases about anything, not just about individual rights, but about who can sit in the cabinet, even who can be prime minister, the ongoing course of military operations, foreign relations, what should be the quota of refugees from various countries. As they have Aaron Barak declared an explicit doctrine, everything is justiciable, which means any government policy can be challenged by a interest group, by just a non-profit organization, and the Supreme Court can rule on it. When the Supreme Court rules on petitions against government action, it sits as a special kind of court, not as a Supreme Court hearing appeals from lower courts, but as a court of original jurisdiction, where it decides on petitions without lower court proceedings or without any evidence. Hold on, guys, I would just ask, I'm going to ask for people to post comments in the webinar chat if possible, because there we go, I closed it, we can keep posting, it's a little distracting. I closed it now. So the Supreme Court decides these petitions without lower court proceedings or evidence. So it abolished all limitations of standing and justiciability, allowing it to reach any issue. It also said that in addition to striking down laws as being inconsistent with the basic laws, they could also strike down government action as being unreasonable based on their own notions. And this, for example, could include even who could be prime minister, what a refugee quota should be. And then they went on even further and said, previously, we had thought that one had thought that you could change the basic laws to change the organization of the system. They said even amendments to the basic laws or new basic laws could be struck down by the court as being against justice or some other higher principles. So in short, the court has declared for itself the right to strike down basic laws, including those dealing with its own powers. Now, the justices are appointed by a judicial selection committee, familiar to people in the UK. It's a 9-person committee. 3 justices sit on this committee, and 2 members of the bar, who almost always vote with the justices. And this gives very strong control over judicial appointments, not just for this, the Supreme Court, but all lower courts to the judiciary. Additionally, the court said that it is per se unreasonable for the government not to heed the advice of its legal advisor the Attorney General. This allows the Attorney General to free veto any government action or any legislation before it was passed, before it was implemented, simply by saying, I think it's unreasonable, or I think the Supreme Court will say it's unreasonable. The government is not allowed to seek private counsel, and if the government wishes to make its own argument in front of the courts, the Attorney General can prevent them and actually show up in court in a case brought by a petitioner without standing and say, the government agrees with the petitioner that our policy is illegal. As a result, the court has vast and untrammeled power. And the goal of these reforms is to restore the situation. And by the way, with the possible exception of basic law human dignity, which was in fact passed by the Knesset, though it's not clear that it gives the court the powers that the court says it does. All of these changes were not made by the Knesset, but were made simply by the judges making declarations themselves, declarations which did not have a consensus, which were hotly contested. And for decades, there has been calls for the reform of the court, criticism of the court by leading jurists from both right and the left. And those attempted reforms have been completely shut down. So even small attempts to have judicial appointments done in public rather than behind closed doors, or to somewhat change the role of the Attorney General, have been shut down by the system. And one question is why to make all these reforms at once, because in a sense it's logically necessary. Because previously, if the government were to simply try to change the role of the Attorney General and say the government is not bound formally by his advice or can seek private counsel, then the Supreme Court could say that's an unreasonable decision or strike down that law. So everything needs to be changed at once for anything to be able to be changed. That said, and this is a very important caveat on which I'll close, the current reform proposals are just that. They are proposals. They are at the earliest stages of introduction in the Knesset. And having been around the Knesset quite a while, I can tell you nothing finishes the way it starts. And arguing against the first draft of legislation is, and treating it as if it's the last, is basically ignoring the typical and standard legislative process in which everything basically gets watered down as it goes. I do not expect all of these reforms will pass. I think some of them will. And I just want to say, if it's best, I think maybe for questions to be fully answered, just to wait to type them for the question and answer period, so as they can all be attended to.
Well, Eugene, thank you so much. Questions have already been flooding in, including where one can find an English translation of the reforms proposed, which I have seen. So we'll work on being able to circulate that to our audience in due course. And we'll take all the questions together after our second contribution from Stephen Hockman. Comparisons have repeatedly been made with the UK approach to government and separation of powers, and importantly, the scope of judicial review in England and Wales. Could you, Stephen, outline the basis of judicial review here and what parallels might be drawn with the proposals being made in Israel?
Thank you very much. I'll do my best. The first thing I'd like to do is to say something of a quite general nature about our system. Nowadays, I think it's generally accepted that our constitution rests on two basic pillars. The first, of course, is parliamentary sovereignty. The second is sometimes called the rule of law, which is a rather general expression. But I think that one of the features of the rule of law certainly is that the law applies to everybody. Everybody has to obey the law, and that includes, of course, the government, members of the government and people carrying out the government's instructions. That's quite an important point, which I'll come back to in a few moments. So against that very general background, let me deal with what I think are the four main issues that have arisen in this discussion. And I should say that I'm very, very grateful to Eugene in particular for educating me as to what the reform proposals involve. And I'm basing my remarks on the analysis that he has very helpfully provided. So the first thing I think to consider is the relationship between the Knesset and the Supreme Court. And the Supreme Court in Israel, as Eugene's already explained, has acquired a very wide power to review all primary legislation. And my understanding is that the proposals that are being put forward are that that power will be limited to a review of primary legislation which is not part of the basic laws. So anything except the basic laws will be able to be reviewed, but under a more restrictive procedure whereby the whole of the court must decide and there has to be a special majority. So the power of review is going to be restricted, but by no means completely abolished. In our system, just to explain very briefly how that works, the courts generally do not review the validity of primary legislation, but there have been examples where this has happened. So we have had, in the course of our recent constitutional history, some legislation passed which might be thought to be the equivalent of the basic law. An example might be the European Communities Act of 1972, whereby we joined the European Community. Of course, we're not part of the European Union anymore, but while that legislation existed, there were one or two occasions when our courts had to decide whether some other piece of legislation was or was not consistent with the European Communities Act and with European law, which was incorporated into our law by virtue of that statute. So there have been rare occasions when even our courts carried out that sort of review. But clearly, the Israeli Supreme Court's power to do that is much wider, even though it's going to be somewhat restricted under these proposals. Now, the other aspect of this topic, the relationship between the Supreme Court and the Knesset, is, as I understand it, the proposal for the Knesset to override decisions by the Supreme Court. As it happens, I think that under the proposals being put forward, the ability of the Knesset to do that is going to be subject to rather more complex procedures than has hitherto been the case. In the UK, of course, Parliament can always override a decision by any court, including our Supreme Court. Legislation takes precedence over judicial decisions. So our legislature has always had the ability to do that. And it comes as no great surprise to find that the Knesset is able to do the same. So that's a description of the relative powers and a comparison between the two systems under that particular topic, the relationship between, if you like, the courts and Parliament. The second point that I think one ought to cover is an issue relating to the powers of the Supreme Court itself, because there is, as Eugene mentioned, the Israeli Supreme Court has had the power to review matters, I think both legislation and official administrative decisions, on the basis of what is called reasonableness. And this is perhaps comparable, though not identical, to the power which our courts have to review not legislation, but to review administrative decisions, governmental action, local government, central government, whatever it may be. Our courts can review those decisions not merely on the basis of whether they're reasonable or not, but certainly on the basis that the decision was one which no reasonable decision maker could possibly have taken. For instance, if a totally irrelevant consideration is taken into account. And that is a very important power which our courts have, and very much inherent, we think, in the rule of law itself, which I mentioned earlier. So if the proposal in Israel is, as I believe it has been, to prevent the courts from reviewing governmental action on any sort of reasonable or rationality basis, then that would represent a significant difference compared with the powers which our courts have. And I gather that on that particular proposal, even President Herzog has recently expressed his reservations in that regard and suggested that there should at least be a test of what I think he called extreme unreasonableness, which sounds as if it might be rather similar to the UK concept of irrationality. So there's certainly a point of difference there. I'll just mention very quickly that other differences are, as Eugene mentioned, that in this jurisdiction, there are rules about standing and there are rules about justiciability. They're not very precise rules, and judges sometimes disagree about their about the way those tests work, but there certainly are such rules, and that's another point of difference. Then thirdly, let me come on to deal briefly with the question of how Supreme Court judges are appointed, because I understand the proposal to be that the commission which appoints justices in the Israeli Supreme Court will have different membership and will be weighted more in favor of the government. Here, what happens is that a special panel is set up. Its membership is provided for, I think, by statute. It does include senior judges, but they're not in a majority. Indeed, some distinguished jurists have recently suggested that in our jurisdiction too, the government should have more influence over the way Supreme Court justices are chosen. I don't think there are any particularly precise rules about this, or rather any particular clearly defined criteria about how one should do this. What I can say is that in our jurisdiction, as in the case of the proposals made in Israel, the judges are in a minority, although, of course, if you have, for example, the president of the Supreme Court as a member of the panel, then no doubt, rightly and understandably, he will be an influential voice in the decisions. So that's on judicial appointments. Then finally, and this is an interesting issue, on the role of the Attorney General. We have two law officers, an Attorney General and a Solicitor General, and their role under our system is, yes, to advise the government, and they're allowed to give the government confidential advice, and the government doesn't have to disclose what that advice is. But by convention, and conventions do play an important part in our system, by convention, the Attorney General and the Solicitor General have to give their advice independently and objectively. They have to arrive at a conclusion as to the law which they think is correct, and they have to give the government advice accordingly. And of course, it's then up to the government whether it complies with that advice, but it would probably be rather unwise not to do so. And in our jurisdiction, you might be interested to know, there have recently been concerns that advice given by the law officers have not always been as independent as they should be, or as objective as they should be. There's recently been a parliamentary inquiry looking at this, and I think that there is still a consensus that the way we do things is the way they ought to be done. In other words, to have law officers who are objective, but who give the government confidential advice, as all legal advisors do in respect of their clients. Now, the proposal, as I understand it in Israel, is that the advice of the Attorney General will no longer be binding. Well, one can quite understand why you might want to make an adjustment there. But the proposal also is that the government should be able to take advice from anyone and operate on the basis of advice from anyone in the private sector to whom it chooses to go. And that would be going along quite a lot further than our system allows, and it would not contain the safeguard of objective advice by law officers which in our system is regarded as important. So that is an incredibly swift run through of the 4 key issues, and I look forward to the discussion.
Thank you ever so much, Stephen. It is inevitably a swift run through in the hour that we have to address what are complex and issues that concern deep-seated disagreements. Perhaps I can begin with a question that goes to the essence of what a constitution is. And I appreciate that we have joining us in the webinar today lawyers from a variety of legal traditions and jurisdictions who will inevitably come to this question with slightly different perspectives. But the first question that's been posed by the audience is, it appears that the resistance to reforms within the Israeli population is rather based upon the questionable integrity of the supposed reformers in the coalition due to their past and present legal woes. However, could this be Israel's constitutional moment? Now, Eugene began by explaining what the basic laws are, and that in the origin, they didn't necessarily have a constitutional status. Clearly, many people argue that they have come to be treated as constitutional in some form. Stephen, can I begin with you? Do you see any parallels with an unwritten constitution in the UK, and how would you assess the structure in Israel against that?
Well, I touched on this, but let me enlarge on it slightly. So I don't think it's particularly helpful to describe our present constitution as unwritten. I mean, in the first place, it undoubtedly is written down. There are several substantial textbooks on constitutional law in which the authors tried to describe what our constitution is. So undoubtedly, it can be written down. But I think what people mean is that it's not codified in the way that the American Constitution, for instance, is codified. And for that reason, as I said, other than in fairly rare instances, our courts do not have the right to review primary legislation in order to decide whether that legislation is in accordance with the Constitution or not. The only possible exception to that is that under the Human Rights Act, our courts have now acquired the right to decide whether legislation is or is not compatible with the European Convention on Human Rights, but they don't have the power to strike the legislation down, only to decide and declare whether it's compatible or not. So under a non-codified constitution, one which doesn't have a separate document, that's normally the situation. As I said, well, I'll leave Eugene to comment on the Israeli position. It seems, I think, to most people here that our position is reasonably satisfactory. Many of us, in an ideal world, would like to see a codified constitution which would impose more restraints on government, but that would be a very difficult thing to introduce at this stage in our history. But to achieve greater codification, for instance, on ministerial powers and on ministerial behavior, is something which is certainly under close consideration here at the moment.
And Eugene, what do you make of the question as to whether this is a constitutional moment in Israel? Up until now, a codified constitution, certainly it doesn't have. You're on mute, I'm afraid.
According to the defenders of the Supreme Court, Israel already had its constitutional moment, which, by the way, is described by the judges themselves on the Supreme Court as a judicial revolution. That is how they described their action of asserting the power of judicial review, the power to strike down government legislation for being unreasonable, delegating the power to the Attorney General to pre-veto government decisions. They called that the judicial revolution. And they claimed the fact that the Knesset did not block it at the time is proof of its legitimacy. But what the Supreme Court in Israel claims is far broader than anything any UK court could ever claim, because they claim the power not just to strike down primary legislation, but again, the power to strike down sort of constitutional statutes to prevent any change in the current system. So, for example, you had the European, Stephen mentioned the European Communities Act. Britain joined the European Union, Britain left the European Union. Nothing is locked in. And the fundamental point of parliamentary sovereignty in the UK is that one parliament cannot bind another, because why should today's majority, right, they have a mere majority, it only takes a majority to make a parliament, bind a future majority. Now, one answer to that could be the American answer, right? If the current majority has some kind of super majority, they can enact legislation that shows extraordinary consensus and deliberation. But other than that, a momentary majority, why should one momentary majority control? The argument in Israel made by opponents of reform is that arrangements that were achieved even without any parliamentary majority in the past 20 years are permanent and can't not be altered, or the Supreme Court gets to decide whether they can be altered. Now, so this is a constitutional moment in the sense that if this legislation is passed, this legislation, it's important to point out, for the first time explicitly legitimizes judicial review by the Supreme Court. Right, that is to say, it says, yes, we agree, the court has this power, but we are putting also checks on it. So that is a constitutional moment. On the other hand, if the efforts to derail the current reforms, in particular by marshalling international pressure, opponents of the reform have gotten the Venice Commission, Secretary Blinken, and a bunch of other people involved. If that pressure causes it to be derailed, it is quite clear that the Supreme Court will say, you see, there was a constitutional moment. There was a challenge to our way of life, and and yet our way of life was preserved. And as a result, we can, the Supreme Court will surely say, if this reform is derailed, that they can do anything they want. Remove a prime minister, declare a prime minister the wrong guy, the people elected the wrong guy. He's corrupt, he's whatever, unconvicted but corrupt. So clearly, a lot hangs in the balance, because the status quo will not be maintained. If the Supreme Court's powers are not limited now, there will be simply nothing they cannot do.
Eugene, there's a question that you've both in fact answered, but I'll draw it out nonetheless. It's, does the Israel Supreme Court claim to derive its powers from specific statutes, or does it claim they are inherent powers of any supreme judicial body in a state operating under the rule of law? Stephen's explained that the Supreme Court here operates in accordance with the statutes that Parliament pass, and by contrast, your explanation has been that the Supreme Court in Israel is given these powers onto itself. They aren't inherent in any statute passed by the Knesset. Is there anything that you just want to add in light of that question?
The Supreme Court does claim that some of them derive from basic laws, but they also claim that they can decide which basic laws can be passed, so that future basic laws or amendments to basic laws can be evaluated by the Supreme Court.
In that case, can we just drill down into the basic law on human dignity, which began very much of this process? Could you comment at all on the extrapolation from the text of that law of the principle of equality, which is certainly focused significantly in decisions that the court has made since the passing of that law?
Yeah, so that's very interesting. Let me just pull up the text. So the basic law of human dignity was passed in 1992, and it says it protects certain basic rights, in particular the right of life and the dignity of person, protection of property, liberty, privacy, and leaving and entering Israel. It also says in a basic preamble that it's founded on basic values and general human rights, and that all people are free. When this law was being debated, there was a specific discussion whether to include equality. And equality was excluded because nobody knows what equal really means in relation to what. Does it mean that the ultra-Orthodox are not allowed to have separate events with women and men because that's not equal? Or does it mean that they should be allowed because otherwise the ultra-Orthodox would not have equal ability to hold public events? Does it mean that it is illegal for Arabs not to be drafted? Maybe that's a violation of equality. And these are massive issues. Who should be drafted? What about the ultra-Orthodox? What about the Arabs? Under what terms? And so it was decided to exclude that. But nonetheless, the Supreme Court inferred in the general principles of preservation of fundamental rights in this text that nonetheless there is some kind of protection of equality, though it was explicitly excluded. And this is why I just want to get back to John. I want to get back to Stephen's point. That simply coming up with a higher standard for reasonableness, why is that not being proposed, right? The Supreme Court now reviews legislation for reasonableness. Why not just say for extreme arbitrariness? And the sense amongst the reformers is that simply changing the linguistic barrier is not going to be a guard against the Supreme Court. You need clear, bright line rules, because if not including equality does not prevent you from getting equality, getting the Supreme Court to say they can strike down laws as being unequal. And by the way, that's what led to the 5 rounds of elections, was the Supreme Court held that the compromise between the secular parties of Lieberman and other parties and the ultra-Orthodox about the Haredi draft was not good enough and violated equality, leading to 5 rounds of elections. So that's why there's a sense that you need really clear formal constraints, because there's everyone thinks if you give them an inch, they can drive a truck through.
Natasha, could I just comment briefly on one point that Eugene just made, because I think this crystallizes rather clearly what the issue is. I mean, I understand the point that for those who are anxious about the power that the Supreme Court has to strike down not just legislation, but perhaps more importantly, administrative and governmental decisions on the grounds of reasonableness. That is giving them a very wide power and unbalancing things. But I think probably the argument that's made on the other side is that if you strip away those powers completely, if the courts in general are deprived of the opportunity to test decisions on the basis of rationality as we do here, then that gives government itself much greater power, and it exposes the citizen to irrational conduct on the part of government. For example, irrationally discriminating between different types of people. I think a very extreme example that was given in a famous case once was if a government decides to treat people with red hair differently from other people. And I mean, yes, of course, that's an extreme example and perhaps unlikely to happen in practice. But if you don't have a rationality test, and if there's nothing to stop government from behaving in that way, then you do have a problem. And so I suppose the question is, which would you prefer? Would you prefer a Supreme Court which had some powers which you think could possibly be misused, or at least used in a way that not everybody would agree with, or would you rather have a system in which government was given much more untrammeled power to decide irrationally in relation to the citizen? I think I know which of the two I would prefer, but I'm trying to avoid expressing any political opinions.
Well, I think the diplomatic, or at least the lawyer's answer, would be that the construct of the balance of powers is that it is in fact a balance. And that is one that is inherently difficult to achieve. And Israel and the UK are not the only countries struggling with that process.
Can I respond to Stephen's point?
Can I just very briefly hone in and then please tell me if you disagree, Eugene, the difference though between the Wednesbury unreasonableness test, which is applied absolutely to deal with irrationality and decisions that are very much defined as that, is in the UK at least circumscribed, whereas it does appear in terms of the decisions that have been prompted by the Israeli Supreme Court's deployment of the like-worded test of reasonableness, perhaps, is a very different beast if it is in fact the court judging one policy against another as opposed to irrational behaviour. Eugene, would you be able to give us some examples of where the court has deployed that test?
I just want to say, when we're talking about what it would be like if the balance were different, more in the way of these reforms, we don't need to speculate. Right? We don't need to entertain sort of redhead hypotheticals. So don't worry, Natasha, because this is how the Supreme Court assumed this power to invalidate government decisions on this ground in 1993, right? And before 1993, I don't recall. Thomas Friedman had an article in the New York Times saying this is going to be the end of democracy. He was the Jerusalem bureau chief from 1988 to 1990 something, and he was not saying there's no democracy here and redheads are being abused. And that was during a time when there was one party rule throughout, or one coalition rule throughout most of Israel's history. Things are much more divided now. So the Supreme Court, when it evaluates reasonableness, it says whether the government has properly balanced different interests in society. And nobody has a balancing scale for different interests in society. And I think when Stephen made his point that what he'd prefer, you do this, I assume, with an assumption of existing British limits on the court, such as one of the things whose reasonableness they will not be considering is the reasonableness of having a prime minister who is under criminal investigation when the governing statutes clearly do not bar someone under criminal investigation from serving as prime minister. They only apply to certain kinds of convictions. Or they would not consider the reasonableness of a set of military policies. In Israel, the route of the separation barrier, which may well be a future border for Israel, and it certainly has a vast security and defense implications, was drawn up by the Supreme Court, 50 separate cases challenging the reasonableness of different routes because they burden private property owners. There has to be eminent domain, and between security and eminent domain considerations, it's hard to imagine that happening anywhere else. So two fundamental points. First of all, we're not talking about some hypothetical fantasy world. We're talking about what things were in fact like before 1993. You don't need to compare systems. Compare to Israel before 1990. Rabin's Israel. I don't recall it being denounced as a undemocratic system. But also, the criticisms of the reforms focus on human rights decisions. But in fact, the court's human rights decisions are not those that gained are its most notorious or most controversial on the right. Someone mentioned there's not going to be women in combat units. The Supreme Court has not mandated women in combat units. That's been a series of government decisions, which are largely incomplete in certain units. The Supreme Court has actually permitted discrimination between Arabs and Jews in a series of cases about private property. So the Supreme, the cases that are controversial are cases: can the Supreme Court draw the country's borders? Can the Supreme Court pick high government officials? Can the Supreme Court set refugee quotas? These cases deal, have nothing to do with human rights. And the critics of the reform have never said, maybe let's fix all that and leave the rights issues to another day, because the rights issue is not the one that is most that is in fact the most controversial issue. When you have the power to say the prime minister is not eligible to be prime minister, you in effect have power over the entire rest of the government, and everything is a lesser issue. Right? That's the only power you need to have supreme power, is the power to fire cabinet members and the prime minister.
In our last 15 minutes, I'm going to fire through as many of the questions as I possibly can, because they've been flooding in. Can I start, Stephen, by putting a couple to you that have been asked about the UK? The first is, how can the British AG be neutral if he or she comes from the ruling political party? Now, you referenced certain controversies that have arisen recently, but could you respond directly to that question?
Yes, I mean, it's an understandable question coming from anyone who hasn't lived in the UK and isn't familiar with our system. And as I said, our system in this respect, I think, does rest on convention, and it rests on the trust that we place in individuals. And of course, they are invariably qualified lawyers and almost invariably very, very distinguished people of great integrity. We trust them to give objective advice. Of course, since the advice is confidential, you may never know what advice was given, but on the whole, it seems to have worked. I'll take that theme from Eugene's last answer. It seems to have worked in our jurisdiction, but it's certainly not impregnable. And as I say, we've had some recent instances where the way things were done has been questioned, and a parliamentary inquiry stopped short of recommending some form of serious reform, but was very concerned about the situation.
Let me draw a sharp contrast here. In Israel, not only is the Attorney General's advice not confidential, Attorney Generals act, as I could only describe it, as political figures, and have at various times recently, the current Attorney General, the prior Attorney General, in high-profile policy issues, held press conferences to denounce government proposals as illegal and saying that they will argue against them in the Supreme Court. It's not only not confidential, it's the opposite.
It strikes me that perhaps the good chap theory of government over here has applied also to legal advisors in the judiciary. But if I can follow up with a further question as to the British courts, Stephen, or perhaps more accurately, the courts of England and Wales, do they accept limitations on their own powers, like the US court's refusal to decide political questions or hear claims by parties with no personal standing? The Israeli Supreme Court has rejected such limitations. So the limitations of standing and justiciability, do you have anything to comment on in terms of how?
Yes, I think I can deal with this quite briefly. I mean, yes, as I said earlier, in this country, there are rules about justiciability and standing, and I think we regard those as important. We regard them as important limitations on the powers of the court. I think one would be inclined, as an English lawyer, one would be inclined to wonder why the Israeli system doesn't consider adopting rules on those topics. But they're not. Again, these things do not give you a magic wand. In a very, very significant constitutional case, which was decided here fairly recently, which was all about the ability of the Prime Minister to prorogue Parliament, in other words, to prevent Parliament from sitting and making decisions which he wasn't very keen on. One set of quite senior judges decided that that was an issue which was non-justiciable, and they refused to grant any order in relation to it. The Supreme Court decided that it was justiciable. I think most people now believe that that was a correct decision, and they said that the Prime Minister's decision to prorogue Parliament was unlawful. So you know, even the question of justiciability can be tested in court, but at least we have that test, and it provides some restraint on the extent to which the judges can get involved in politics, which on the whole they are relatively reluctant to do.
Gentlemen, there are a whole series of questions that have been put that highlight a particular issue, which is that what is being discussed here this evening between us, it is not something that they have heard previously. And I'll read out one of the comments that perhaps highlights the magnitude of this. It reads, "To those of us in the diaspora, it seems the Israeli government has a PR issue. The impression given is that the government is determined to undermine the rule of law, for example, by taking de facto control of the appointment process for Supreme Court judges. The point has not been explained thus far, or the point that has not been explained is that the Supreme Court, according to Eugene, has overreached itself by taking wide-ranging powers that go well beyond notions of UK notions of judicial review. This questioner says, I think there is a good deal of misunderstanding as to what is proposed. I say that to underline the importance of the discussion that we're having, and in particular of comparing these two systems. And perhaps I can follow that up with the question as to the Israeli Supreme Court, in the capacity that it sits as the High Court of Justice. This questioner asks, has it inherited powers of judicial review from the mandate legal system and the ordinance following independence, continuing existing laws unless and until and changed by the Knesset? Do you see there being any follow through from the prior pre-state system?
Shall I just give a brief answer to that question? I mean, it's an interesting idea, but I doubt if it's historically correct, not least because the current system of judicial review in this country is of relatively recent origin. It was. I mean, here's a point of comparison. It was created by the judges, just as the Israeli Supreme Court judges have created their system. It was created by the judges in the 60s and 70s. It's now embodied in, at least in rules of court, but the principles of judicial review are principles of common law. But certainly, I mean, although there were what we used to call, I think, prerogative orders, which the courts occasionally granted, I think our modern system of judicial review is of fairly recent origin and certainly postdates the foundation of the State of Israel.
Eugene, do you have any?
What was the first question? We missed that one. Yeah.
Sorry, the first question was to do with whether or not the pre-state system under the mandate.
So the question before that, you had two questions to follow up on that.
That was the only question.
I think the question was a more general one, which was whether essentially it was just saying that the Supreme Court in Israel has granted itself rather extravagant powers, and if the government is going to take control of the appointment system, then I think the point the question was making was that if you argue in favor of retaining the powers of the Supreme Court, then under the proposals the government are putting forward, what you're really doing is giving dictatorial power to the government itself. I think that was the point that was being put, and that seems to be the concern of many of the opponents of the proposals.
So let me address the dictatorial point. Again, these would be the powers that the government had in 1993. Nobody called Yitzhak Rabin a dictator. Many people called Ben-Gurion a dictator, but it was principally Jabotinsky and his followers, and those were not widely accepted in the world. But nonetheless, this would not, in fact, return it to the 1993 status quo. This would legitimize judicial review. It would give the court the power to strike down legislation. By what majority? I think, by what supermajority remains to be decided. I think the detail, the broad outlines of this legislation are going to be very different from the details, and various things like how many appointments does the government get on the committee and what vote of the justices are required is going to be really quite different. But if one is truly afraid of dictatorial authority, then one should truly be scared of the Supreme Court, because the Supreme Court always has one less check than the government. Right? The government can fire the court can fire the prime minister. It can require refugees to be allowed into the country en masse. It can draw the borders, but what it does not do is stand for elections. The Israeli government does stand for elections on an average of every 2.5 years. And another important distinction from the UK is the coalition system. In the UK, the head of the government, the prime minister, controls the majority of votes. His party controls either at least 51% of the votes, if it's a Tory government typically, or if it's a Labour or Liberal government, 80% of the votes, the party of the prime minister. So in other words, the prime minister has substantial control over either a majority or close to a majority in the legislature. In Israel, there's an internal check within the political system, which is that typically the prime minister's party does not control more than half the seats in the Knesset. So right now, Netanyahu's party has a slight, close to half, I believe, or just more than half of the seats in Knesset, and that's an unusual success, right? There have been prime ministers that have had much less control, which means that to get to 61 votes, you need a bunch of other parties, each with their own agendas, right? And for example, the ultra-Orthodox agree with Likud on some issues. They disagree on other issues. They don't care so much about diplomatic issues or issues involving the Palestinians. They're more to the center on those issues. All of these parties have different agendas and constituencies. Indeed, right, we know because the outgoing Prime Minister Lapid, was seeking to make a government with the Haredim, and there is indeed on the basis that there could be potential common ground. There's a lot of and parts of these parties break off. Much of the current opposition used to be in Likud, but broke off. That's true of Benny Gantz's party. So in other words, you need the consent not just of your own party, but a bunch of other parties. So simple party discipline does not get you to 61 votes. It gets you maybe to 30 votes if you're the prime minister, or if you're Naftali Bennett, it gets you to 6 or 7 votes. So that coalition politics shows that 61 is truly hard to get to, as evidenced by the fact the 5 elections Israel has had, and the number of small parties make the defection of one party who very easy in response to potentially a controversial vote. That's principally relevant to the override clause, which in any case I think will not be passed. But if one is very concerned about absolute power, one needs to say, where was this absolute power before 1993? And why is it why is it better for unelected people to wield absolute power rather than elected people?
Your answer has incorporated answers to a number of other questions, for which I'm very grateful, and it's very efficient. Can I follow up with one further one, which is, do you think that the balance of power might be swinging too much in the opposite direction if the reforms come to pass by giving the government the power to make all Supreme Court judicial appointments? I'd ask you to address perhaps the premise of that question as well. And I take on board your earlier remarks that, of course, what is being proposed in the first instance is unlikely to be what comes out at the end of the sausage machine that is the Knesset passing legislation. But could you deal with the question as to whether this is swinging too much in the opposite direction?
Okay, go ahead, Stephen.
Okay, well, I mean, Eugene is the expert, but I've already indicated, I think, that to my mind at least, there are at least 2 legitimate points of concern. One being the proposals in relation to the legal advice available to the government, which is and the criteria there are going to be relaxed, and the other is in relation to the grounds for judicial review, where this what I've labelled the rationality ground is going to be removed. All I would say is, and I think we're all aware that at the moment these issues are very controversial. The only benefit of that is that it's enabled us to have this extremely interesting discussion. I wonder, and I'm saying this with tongues only very slightly in cheek, I wonder whether there isn't scope for a commission of people to be appointed and to discuss how best to solve some of these problems, a commission of constitutional experts. I'm sure that Eugene and I would be delighted to become members of that commission if we were invited to do so, and the audience will have to judge by reference to our answers this evening whether they think that it would be helpful for Eugene and myself to get together to try to solve the problem, along with some other experts too, of course.
Let me end very briefly. I like this image of the pendulum swinging too much to the side. It's very hard to get a perfect balance in constitutional balances of power, and part of those balances depend on preferences which vary from country to country, trust and whatnot. The question is is it within the parameters? The question for people in the UK, is it within the parameters of Western democracy? And if one was not, thinking Israel is not a democracy when the pendulum was here, oh no, the Supreme Court has too much power, it's not democratic, we're outraged and we're not going to be friends with Israel, then one should not have that reaction when the pendulum swings over here, because in no country is the pendulum here, except, one's own if one's very comfortable with it. But pendulums swing back and forth, and it's a process. And a final point, if the pendulum swings this way now, the next Knesset can push it back. Nothing here is entrenched. It's all up for debate. It's all up for revision. But if reforms are not made now, the Supreme Court will surely understand that it has absolute power.
And of course, it's important to note that that pendulum is swinging between the court and the Knesset, not between political parties. And as you say, reversible. And who knows what the next government in Israel will hold. Stephen, I thought you were going to suggest that there may be scope for a further webinar, because I have never had so many questions that are pertinent and important that I simply have not had the opportunity to put to you. And I have to apologize to the incredible number of questioners who have made those points. They are incredibly valid. I agree with many of them. And we will have to continue this discussion as matters develop and undoubtedly as these reforms go through the Knesset. I'm only sorry that we've only had the hour. We haven't been able to do the topic justice, but I do believe, especially from some of the comments in the chat, that we have covered ground that has hitherto eluded many of the discussions. And for that, I'm enormously grateful to both of you for providing, I should say, a unique perspective in terms of the comparison of judicial review in the UK and Israel. Thank you very much for joining us.
Thank you.
Thank you.